Good morning. Good
Hi,
afternoon, Your
how are
Honors.
you? Okay. We have everybody?
Yes, sir.
Okay.
Good afternoon. This is Allegra Knopf of Aldrich Pite on behalf of the Appellant Bank of New York. I would request 5 minutes in reserve, please.
Sure.
May it please the court?
Go right ahead.
Okay. Your Honors, this is an appeal of an involuntary dismissal of a residential mortgage foreclosure. The basis for the appeal was that the court held that the plaintiff had not proved compliance with conditions precedent. We have appealed, however, because we believe that that was an error. Our argument is that we were prevented from admitting evidence which should have been admitted, and that the court abused its discretion in not allowing us to admit the default letter as well as proof of mailing the default letter.
Let's assume that Binger does apply.
Yes.
Why didn't this satisfy the Binger test for exclusion of evidence that was not disclosed?
Your Honor, well, there was no trial order that required us to disclose all of our exhibits ahead of time. There had not been a specific request for that. But in this case, the court didn't even do the Binger analysis. It simply held that there was prejudice to the defendant.
Yeah, and there are cases that have reversed based on the failure to go through the Binger analysis. But you're also the appellant, and I'm curious, then there was some analysis done. It was not just there was not ipso facto because it was not disclosed, I'm excluding it. What if we did apply the Binger? If he or she, I forget what. If the trial court had applied the Binger factors, why would that be an abuse of discretion to exclude the evidence?
Well, because the plaintiff had suggested continuing the trial. And under the Binger analysis,
did the plaintiff suggest that, or did the plaintiff just acquiesce to the trial court suggesting that?
The plaintiff actually did suggest it. Now, I will concede that there was not.
Is that okay?
Yes,
I don't recall reading that the plaintiff, and I also recall, I don't mind pivoting to that because it is important to me in my thinking, because it is in subsequent cases to Binger, it talks about the fact that trial courts should at least think about continuance. The plaintiff's counsel was provided a second time after that continuance discussion was to explore other options and said, no, I'm going to keep questioning this witness. Am I correct?
I think you would have to interpret how I can't speak for the actual trial attorney at that time. I don't think that I did not obtain that.
We're both just reading the record. What?
I did not obtain that impression from reading the transcript, Your Honor.
So it taught me through how the plaintiff pushed for lack of a better term, a continuance.
Well, on page 37 of the transcript, the plaintiff did suggest a continuance. Then defense counsel objected to the continuance. Based on my reading of the transcript, my understanding was that the court had decided to proceed because defense counsel objected to a continuance. That is how I read it, but you may disagree. But there's another point that I wanted to point out. It's not just the Binger, but there's also, even the Kozel, for example, albeit it dealt with a case where the dismissal was with prejudice, and in this case, it was not with prejudice. But I think Kozel versus Ostendorf still illustrates and gives guidance to the court when they're looking at potential dismissal and whether or not there was any untoward conduct by the plaintiff. In this case, it was plaintiff's counsel made the error of not providing the proof of mailing the demand letters ahead of time. That was an omission which was a mistake. It was not intentional in any. Yes, ma'am.
It was a little more than that, though, wasn't it? It wasn't just that, oh, oops, we forgot to send you these last 2 pages of the exhibit. It was throughout the entire litigation, they had plaintiff was saying that the letter had been sent by first-class mail.
It was sent by first-class mail, but there's also a certified receipt. I think one of the confusing things about the record is it makes it sound like, or at least defense counsel made it sound like it's either or, whereas it could be both. I'm
going to ask the other counsel the corollary, if that's the right term. But is there record evidence that would suggest that first-class mail and a return receipt, or first-class mail and certified mail, are incompatible or mutually exclusive?
No, I don't think so.
But
Your
your
Honor.
understanding is that it's not.
Correct, yes. Because well, and with regard to one of the things I wanted to point out to the court also, though, was that with the testimony that our witness provided, with regard to the demand letter or default letter, that was clearly from the corporate representative's records. They clearly made they clearly testified as to its admission as a business record. However, when the court ruled, it ruled to not only exclude the certified mail receipts, which had not been disclosed, but also to exclude the breach letter or the default letter, which had been disclosed. That was not any kind of surprise to defense counsel. So I think that was an error in not allowing that in. But there's also the issue of whether or not I think there was predicate laid for admission of the return receipts, that the witness did testify that he had reviewed their business records. He had testified about the boarding process, and he testified that the return mail receipts were in their business records.
No, can I stop you there for a minute?
Yes.
Your witness, Banks' witness, said I think it was he laid eyes on it in the digital system.
Correct.
Yeah. So was there a reason why that? I recall a best evidence rule objection maybe. Was you reading the record that testimony was excluded, or was that testimony in evidence? And if it was, would that be sufficient to withstand a involuntary dismissal with regard to the condition precedent?
Well, the specific exhibits were Exhibit 7, which was the default letter, and 7A and B, which were the two sides of, or the two return receipt documents. The judge did not allow admission of 7 or 7A and 7B, and therefore held that their plaintiff failed to comply with conditions precedent. I did want, though, to also point out about the court's reliance, the case law that the court relied upon. The argument that defense counsel had made was that because the breach letter had been sent or had countrywide on it, that there was no way that the witness who was from Bayview Loan Servicing would be able to testify about how that letter, the demand letter or default letter, was mailed. And he cited Spencer versus Ditech Financial, and he also cited Sewell versus U.S. Bank National Association. Those are two second DCA cases, which of course hold that you cannot, that the witness, if they're going to testify about the manner of how the default letter is breached, they must have some familiarity with the process. In this case, the witness did concede that he was not familiar with countrywide procedures. However, we did have evidence through the green card. And I think both Sewell and Spencer, they both say that you can use evidence such as a return receipt for proof of mailing. It doesn't have.
Let's assume that under Binger it was properly excluded if Binger applies, and the documentary evidence is testimony that, hey, I with my own two eyes saw it in a digital system. Is that sufficient under Spence and Sewell, or not even Spence and Sewell, just under case law regarding evidence to withstand involuntary dismissal regarding the receipt or mailing of the default letter?
I think if you have testimony of the boarding process, that they have reviewed these documents that they obtained from the prior servicer, that they relied on the documents by the prior servicer, and that they became part of the current servicer's records, then I think it is sufficient.
Even if the finder of fact doesn't get to lay eyes on the document?
Well, they would have eyes on the document. I mean,
no, because it was excluded, and we're here because it was excluded. The green card was excluded.
The green. Oh, I see. Well, Your Honor. Well, it was proffered. It was proffered.
Assuming that it was properly excluded, was his testimony that, hey, I saw a return receipt signed by the defendant sufficient to withstand involuntary dismissal based on a failure of a condition precedent?
I think so, Your Honor, because he's testifying based upon his corporate business records. He's testified.
Well, that doesn't. The business records. Okay, go ahead. I'm sorry, go ahead.
Well, most of the records are, of course, going to be through the business records. And he did testify when on direct examination. He said, "Was the breach letter sent to the borrower at the address?" And the answer was yes. That his review of the record showed that the breach letters were sent, and that there was proof in the form also of the return receipts of the green cards. The concern, Your Honor, is that basically by not allowing any continuance to have occurred or allowing us to proffer it, basically the court made it impossible for us to proceed to judgment. And the result was a harsh result. I would point the court out to Wells Fargo Bank versus Chatham, which we cited, and that court found that it was an improper sanction to dismiss involuntarily.
Now, this wasn't, the sanction was not dismissal. The sanction was exclusion. And it was Chatham, the case in which the court found that the exclusion amounted to a death penalty for the claim, or was that another?
It holds dismissal as a particularly draconian sanction in this case because.
Okay, would you agree that the sanction was not dismissal, the sanction was exclusion?
Yes, sir.
So, and that the unfortunate consequence to your client was that involuntary dismissal, I mean, notwithstanding what we're talking about a minute ago, that involuntary dismissal was warranted? In other words, it's the involuntary dismissal is incidental to the sanction of exclusion for the discovery violation.
They go hand in hand, correct? Yes, basically, I mean, that was the net.
Do you have any cases in which a sanction of that sort, which was not dismissal itself, but which only had the consequence of dismissal, was reversed because it was not commensurate?
Your Honor, I would have to rely upon the Cozell factors, that dismissal is just too harsh, because in this case, there was nothing that our client did wrong, but our client is bearing the burden of this. And there was no consideration about whether there had ever even been prior sanctions. I mean, there wasn't even an order requiring us to disclose all of our trial exhibits prior to trial. So there was
but there was a bunch of interrogatory questions and requests for production.
The request for production asked for the breach letter, correct? And we did send that. I
think they're a little broader. They asked for, in other words, let's assume, even though it's probably outside the record, so we just have to assume one way or other that first class mail is not mutually exclusive with a return receipt or a certified mail.
Correct.
Okay, so that was not an affirmative misrepresentation. If we assume that you could be first class and also have a return receipt, but that was the moment during discovery when, if you had the goods on the defendant, hey, I got this return receipt, that's when it ought to have been disclosed. And when you think about Binger, right? Like, hey, I got this, I caught you red-handed. You signed this.
Well, if we didn't have it prior to well, we had it. We offered it. Yes, we had it at trial. We didn't have it prior to trial. So we had it there. And I think that the equitable thing to do would have been to continue the trial, because defense counsel objected because he said he wanted to take depositions because of this.
What if we read the record what if we read the record to infer that there wasn't a request for a continuation of trial?
Well, there still was a failure by the court to examine any of the Binger factors. The court said, I'm not going to allow this in. And he did not allow didn't even consider, an ability to cure the prejudice, whether this was an accident or intentional, and how this would disrupt the trial. There was no consideration of any of that. In other words, it was like, okay, plaintiff, tough, you're gone.
I kind of doubt your opposing counsel will read the record that way. There was no consideration of those things, even though, yes, Binger factors were not applied explicitly nor mentioned. One of the first factor, of course, in Binger is prejudice in fact, and I plan to ask opposing counsel about that. Don't you agree that they established, or at least with regard to our abuse of discretion standard, they established prejudice in fact, because they said, well, if I had known that there was this green card, I would have conducted discovery to try to impugn that piece of evidence, and I was not permitted to do so?
If they had asked for proof of mailing, I did not see a request for proof of mailing in the request for production, but I'm not going to object that it didn't cause a surprise. I'm not going to object that and say that it didn't. It did cause a surprise at trial. I agree with that. But our disagreement is with how it was handled at the trial court level, that it should have been, we should have had an opportunity to cure, that there should have been a continuance so that this is a 2009 default, so that we wouldn't have to start over again. And particularly since it was due to no fault of the plaintiff, and now the plaintiff is having to face the consequences of this.
So you're talking, I think that's a binger. Okay, I understand.
But Your Honor, I think also that the case law that the court relied upon in the Sewell and the Spencer cases, are distinguishable in this case, that it's not the same, because in this case, we did proffer the return receipts. In that case, there was no such proffer. As a result, Your Honor, we believe that based upon the testimony that was provided, that because they were in Bayview's business records, even though the breach letter came from Countrywide, it still was part of Bayview's business records. The witness testified that it was part of their Bayview business records. As a result, it should have been admitted as a business record.
It's not, you're at your rebuttal time now.
Okay, I'll yield.
Okay. Okay.
Good morning, ladies and gentlemen. May it please the court. My name is Scott McKay, and I'm an AV-rated trial attorney in Bradenton, Florida. I represent the appellee Ryan Brown in this case, and it's my pleasure and privilege to appear before you today. I'd like to take up some of Your Honor's arguments after I address the standard of review, because the standard of review matters in this case. When you're reviewing a judgment after a non-jury trial, the findings of fact come to this court with a presumption of correctness and will not be disturbed unless they are clearly erroneous.
Well, this is an appeal from an involuntary dismissal. So all inferences are, any evidence from which an inference can be drawn in favor of the plaintiff should be credited, right?
Certainly, but the findings of fact come close to you with a presumption of correctness. Now, when we get to the standard of the exclusion of evidence, which Your Honor has addressed, in Ray versus State, the test was a clear abuse of discretion. The majority of the other cases seem to speak about it simply in an abuse of discretion standard. So it's either a clear abuse or an abuse of discretion. Now, interestingly, the Second District Court of Appeal has a test on what happens when a trial court denies a motion for continuance. And I would respectfully disagree with the presentation of my opposing counsel. The appellant's trial lawyer never once moved to continue this. That was suggested by the trial judge, which was Judge Lee Hayworth, a 30-year veteran of the bench. He initially suggested the concept of a continuance, which I objected to. The appellant's trial counsel never once made a motion to continue. There was a break taken that Your Honors have seen in the record for opposing counsel at trial to go through the record and figure out the issue with the green card. After the green card was excluded, the trial judge gave them the opportunity to do something. He gave them a break and said, what do you want to do? That was the invitation at that point for opposing counsel to say, we need a continuance, which I still would have objected to. But the second DCA's test for denying of a motion of continuance is that this appellate court must find a clear showing of a palpable abuse of judicial discretion. That's the standard. Comes from a case called Fassig versus Fassig. A clear showing of palpable abuse of judicial discretion. It wasn't there. I heard Your Honor wanting to talk about Binger. Let's talk about Binger, because there's really only two cases that govern this, and one of them is Binger. Binger, when you read it, is a Florida Supreme Court case, and Binger applies only to the exclusion.
There have been cases of this state, recorded opinions of this state that applied Binger to lay fact testimony and to documentary evidence. Am I correct?
I have seen one case, not from the second DCA, that talked about documentary evidence. Every other case that I saw on Binger was testimonial evidence. Binger started with the exclusion of a witness not listed on a witness and exhibit list. That's where Binger started. Binger specifically limits itself multiple times in the decision to that fact pattern.
You don't think it kind of they hedged in that footnote and said, well, it could.
They hedged. I don't disagree with you. But when you look at all of the cases you're talking about, what Binger gets applied to most now, and I've seen a lot of those cases, is witnesses that change their testimony between the time that they're deposed and between the time of trial. Binger is still a witness exclusion and that kind of a case. Now, the second DCA had the opportunity to take up the Binger analysis in a case called Florida Peninsula Insurance Company versus Newland. The Binger test was directly before the second DCA's eyes. They per curiam affirmed without expanding Binger. And Justice Lucas, in a nicely written concurrence, went pages and pages and pages talking about Binger. And I'll give you the quote from Justice Lucas. It says, "Nor have we ever held that Binger must be applied beyond the context of undisclosed witnesses or undisclosed expert testimony, period." That's Justice Lucas's review of the law in the second DCA is we've never applied Binger to anything outside of undisclosed witnesses or undisclosed expert testimony. That's not what we have here. We're not dealing with the witness. The bank brought a witness. So Binger does not apply. Clearly does not.
Well, Judge Lucas was writing for himself.
I understand. The remainder of the court just did a per curiam affirmance.
The remainder of the court, or was there another opinion?
There were two concurrences in that.
There was a PCA with a concurrence. Is that what you're saying?
I only speak up because you said the remainder of the court per curiam affirmed, and I'm not sure that's accurate.
Okay, the court per curiam affirmed there were two concurrences in that decision.
Okay.
One was Judge Lucas, and then there was another concurrence. I don't remember either of them taking up the cause. I remember the second DCA definitely having the ability to expand Binger, but Binger.
Well, the other concurrence, and I don't want to be vain, but the other concurrence did open the door to broadening of Binger to include things other than Judge Lucas would include. But let's just assume for the sake of discussion that Binger does apply, or we like other courts would decide that it does apply, since the slate is clean, given that was a per curiam affirmance. Why would the test militate in favor of exclusion here?
Certainly. The trial judge conducted what he called a Richardson hearing at the trial, and your Honor may have seen that. The Richardson hearing, even explained by the trial judge, is the criminal equivalent of what he conducted here. So it's not that the judge did nothing.
Right, he didn't do nothing. But let's start with prejudice and fact.
Sure.
What were they? Tell me about it.
2 months after this case was initially filed, 2 months, I sent interrogatories and requests to produce, and those are important. So what we do is and I'm going to get to the interrogatories because the interrogatories were a good bit more specific than what opposing counsel was talking about. 2 months into this file, the way I try a case at a foreclosure is they have allegations that they have to prove. I want to know what documents they have. So 2 months in, 2.5 months in actually, on December 15 of 2016, I send them a set of interrogatories. Question number 2 and 3 asks them the method that the notice was allegedly sent, by example, regular mail, certified mail, Federal Express, or etc. That's in question 2 and 3. H, any and all other facts that indicate that the notice of acceleration was actually sent. So I ask about your proof that it was sent. And most importantly, interrogatory 2 and 3I. Any other facts that indicate that the notice of acceleration was actually received by the recipient. This was looked at by the trial judge. The perfect answer to question number 2 and 3I, any other fact that indicate that the notice was received is, we have a green card. And here it is. Okay, now we know that it was sent by certified mail. What is their answer to the question though? Their answer is, the notice was sent by first-class USPS mail. Despite what opposing counsel told you, there's no record evidence about the difference between first-class mail or certified mail.
But is there record evidence, I don't want to spend a lot of time on this, but is there record evidence to suggest that first-class mail and a return receipt are mutually exclusive?
There's not. There's no record evidence.
Or that first-class mail and certified mail are mutually exclusive?
There is no record evidence on that.
All right.
What there is right.
But that doesn't take away from what you're saying. I understand that this would have been the perfect time to say, we have a green card.
Not only is it the perfect time, it's the required time. And the trial judge specifically found that we asked the right question about this. He made a finding on that, or at least
So if we say we have prejudice in fact, surprise in fact.
Sure.
What about the Binger factors? Why does this militate in favor of complete exclusion? And what at least one opinion says was the effective death penalty, even if the sanction was for exclusion, the effect of the sanction was the death penalty of the case.
Certainly, and I was meaning to get to the prejudice component. So here's what happens. Two years before trial, we get the bank's answers that this was sent regular mail, not certified mail. I set up an entire defense on this case and spend all the time and energy to get to trial with a notice defense. We had a couple other defenses we could have used. As a trial lawyer, I made a decision to go with the notice defense. So there was a fee hearing in this case. That's record evidence. We spent almost $40,000 worth of time trying this case and defending the case. That's in the record. Where is the prejudice to Ryan Brown? They told us it was sent by certified mail, so we run down that road preparing for a trial to defend on notice.
Don't you need to tell, do you need to establish what you would have done? Because I understand you spent a lot of money and that is an unfortunate consequence, but that can be compensated with sanction that involves money. Do you need to establish what you would have done differently to establish the Binger prejudice?
Sure. What I would have done differently are quite a few. I would have examined the certified mail cards to try to figure out if that was real or not real, who signed it. There's a lot that I would have done to try to figure that out. We had a pretty good statute of limitations defense in this case, but I am not one of those lawyers that wants to bring a bag full of defenses before trial judges, because frankly, I don't think they want a bag full. I think they want your best one. We didn't have a bad statute of limitations defense, but we let it go. I didn't take a single deposition in this case. I didn't depose any of the bank's witnesses that they may have had to try to get around their foundational evidence. I didn't need to do any of that. I would have taken a deposition. I've probably taken 300 depositions in bank cases. I didn't take depositions. I didn't do follow-up discovery. I didn't need to do any of that. That's the prejudice, because I relied, to my detriment, on their interrogatory answers that clearly asked them, did you send it certified? What is your proof that we received it? And they didn't tell us anything. That's what I would have done. And not the least of which is, we would have settled the file. If you tell us you have the certified mail green card and we're set up for a defense on notice, we settle the case. I don't then spend $40,000 of time. We don't do that. The judge found the prejudice. He specifically found prejudice. And
no, I understand. I know that everyone's time is short. I wanted to ask another question. I wanted to ask you about the testimony of their witness that he or she had seen a digital copy of the green card signed by a defendant. Why, under the standard of an involuntary dismissal, why is that not sufficient to withstand an involuntary dismissal?
Because that testimony was stricken. When you look at the record on this, beginning, and the record isn't.
Why? I mean, and I know that wasn't specifically appealed, that evidentiary ruling, but explain.
That was stricken because he was testifying A, about something not in evidence, and B, he still didn't lay a foundation for any of it. So I object.
Well, why do you need a foundation for saying I was involved? We took over, and I looked at the documents, and there it was. I mean, this is 2020. It's 2020. I don't need to look at it in its physical form. I saw it right there that we had a return receipt green card signed by the defendant.
That testimony was stricken. He had no foundation. I don't believe. I understand the boarding process and how banks get prior servicers numbers to move forward, and I understand the cases that do that, but I don't believe they apply the breach letters of green cards. So he attempted to put that foundation up there. I objected militantly to that. I made a sheet of how many times I objected. I was given a standing objection to that issue by the judge.
Well, don't you then also still have the response to the interrogatory? That testimony contrary to the response to the interrogatory.
Well, of course it is. The interrogatory.
It's not an interrogatory. Doesn't just. I mean, you're talking about you're talking about evidence of the certified mailing. You're not certified receipt. You're not talking about just the physical green receipt.
No, my interrogatory 2 and 3I asked any and all other facts that indicate that the notice of acceleration was actually received by the recipient. That could be anything.
That could be, and including testimony that I saw a receipt in the file.
Sure, that could have been notes in the system. It could have been testimony, could have been an affidavit, could have been a green card, could have been anything. We asked them the specific question for any proof that this gentleman actually received the notice, not just the green card. We asked them for anything.
If I'm inferring from you and my colleague, Judge Northcott, that was the discovery violation would have been grounds to exclude that testimony as well.
Of course.
Because that testimony should have been adduced in response to the interrogatory.
Absolutely. Now, but the other interesting component is the exclusion of the green card is not the death knell in this case. He just excluded it. I think the judge could have been correct in involuntarily dismissing the action at that time anyways, but he didn't do that. What the judge did is allow them to put the witness on and try to lay a foundation for the introduction. Now, just being honest, this was some of the worst bank testimony I've ever heard. That witness knew nothing about the breach letter, nothing about the policies, nothing about the procedures. Under the Sewell standard and under Spencer, I asked him the questions that the second DCA put in those foundational tests, and the witness had no information of any kind. So it's not that the judge excluded the evidence and the file absolutely ended, because it didn't. I think it should have, but the judge gave them an additional step. He gave them not a continuance. He gave them a recess to regroup, and then he allowed the witness to try to put together an evidentiary standard with which to admit and prove that the notice was mailed. Don't forget, you do have to do both. You've got to put the letter in evidence, but as Spencer and Sewell indicate, you then have to enunciate the proof that it was actually mailed. They didn't do that. They badly missed that test. Now, to get back
An alternative means to the green card was some sort of testimony that would have substantiated mailing.
Of course, and that's what Spencer and Sewell are all about. Spencer and Sewell don't talk about a green card. Spencer and Sewell talk about what to do when you need to get testimony and what foundation you have to put down. So the exclusion of the green card with the standard of review that it has, that was entirely correct. That's within the trial court's discretion, but that doesn't end the inquiry. If the witness was good, if the witness had the facts that Spencer and Sewell require, the witness could have laid the foundation, put the letter into evidence, and shown that it was mailed, and the bank wins the case. I didn't object to anything else. I didn't object to any of the introductory evidence. So the exclusion of the green card is not the death knell. The fact that the witness was as bad as the witness was, and I feel bad saying it, but the witness laid a terrible foundation in this case. To go back to Binger, because I steadfastly contend that Binger does not apply, we have to talk a little bit about Kozel, but not the least of which is this DCA's rulings in Winter and a case called Bennett, which just came out as well. If indeed it is the take that Binger applies, why is Binger not mentioned in Winter? Why is Binger not mentioned in Bennett? And the fifth DCA has followed the second DCA in a case called Garcia. Binger isn't mentioned in any of those three. Binger said Winter, Garcia, and Bennett simply say that when the dismissal is without prejudice, which the dismissal in this case was indeed without prejudice, you don't need a Kozel analysis. I still contend that while the judge may have used a Richardson hearing term perhaps incorrectly, the judge still conducted a prejudice analysis in his mind. He called it a Richardson hearing. He found the prejudice. No one moved for a continuance. That was the judge's idea, and I think it's error that the trial lawyer didn't do it. But remember the standard of review, even if he moved for it. The standard of review by the second DCA is you would have to find a clear showing of a palpable abuse of judicial discretion. You're not going to find that. And the standard of review that you have is to review what a trial judge did. We're not here to supplant what your honors may or may not have done if you were the trial judge. That's not the test. The test is, was it a clear abuse of discretion to exclude the evidence? The answer is no. You can't find that this was a clear abuse of the discretion provided to a trial judge who was there listening and taking the temperature of the room, reviewing the discovery, and particularly reviewing the interrogatories that we asked and the answers that we received. Now, I heard opposing counsel's statement, which is true, that they didn't have to give us an exhibit list. Okay. But a week before the trial, they sent us an exhibit list. They sent us their exhibits. A week before the trial, the green card is not sent to us. It's not. They sent us 302 pages, I think, maybe it was 320 pages. There's no green card anywhere to be found. The green card is never mentioned, not once. until I get to the day of trial and get to the trial. So whatever they want to say, they answered interrogatories that said, this is regular mail. I specifically asked the question, give me any facts that you have. That could have been a review in their notes system that says, our notes indicate it was mailed certified. Okay, that puts us onto some news. They could have answered that question in a lot of different ways that would have clued anyone into the fact that it may have been sent by certified mail, but they never do that. And because they don't do that, we set up the presentation of this case and the defense on this case based correctly on the fact that it didn't happen. They're not allowed to do what they did at this point. And while I can appreciate opposing counsel's law firm jumping on the grenade saying, hey, the bank sent it to us, but we didn't forward it along, there is no record evidence of that fact. Nowhere are you going to find that fact. The claim that the bank sent it to the lawyers, but the lawyers didn't give it to me, first appears in the appellate briefs. It doesn't appear anywhere in the record below, and I went looking for it. It doesn't show up anywhere at the trial or anywhere around the trial. So that's not even to be considered by this court. The reality of it is the best piece of evidence are the sworn interrogatory answers, which were sworn to by a document witness for the bank with the assistance of a second person. Their interrogatory answers state that two different people went together in the formation of the responses. Their answers, the bank's actual answers, as sworn and verified, said that it was sent by regular first-class mail, and there was no other information provided to us that would indicate it was sent by certified mail. That's the end of the inquiry. The bank's lawyers trying to jump on the grenade saying, okay, you needed to conduct a prejudice analysis. It's just not there. Not only is it not in the record, it's just not backed up by the interrogatory answers that we relied upon. The judge found the prejudice. That finding of prejudice is a finding of fact. That finding of fact cannot be disturbed unless it is clearly erroneous. That's the standard.
Mr. McKay, you're at the end of your time.
I'm happy to answer any questions that you have. Otherwise, I would respectfully suggest that the appeal should be denied and the trial court's findings should be left as they are. Thank you.
Thank you. Ms. Knopf.
Briefly, Your Honors, I did want to just bring out that the standard of review here is, and I'm quoting here from Deutsche Bank versus Clark, that when the appellate court reviews a grant of motion for involuntary dismissal, it must view the evidence and all inferences of fact in light most favorable to the non-moving party. And I did also want to bring the court's attention to the Florida Supreme Court's opinion in Jackson versus Household Finance, which specifically addresses the exclusion of evidence, and that is to be reviewed under an abuse of discretion standard.
But the evidence, isn't there a distinction between the evidence adduced to make the bank's case and the evidentiary findings that support the exclusion, the sanction of exclusion? Those are different. So I think
I see what the
might
court
not,
is.
we might be less able to disturb those facts.
Okay. I did want to, though, also make one other point. One thing that's been clear throughout the record is that there was evidence not only in answers to interrogatories and then discovery, but also in trial that the default letter was mailed. Counsel is arguing that he was shocked or surprised when there was proof, separate proof of the breach letter being or the default letter being mailed, but there's never been an issue in the discovery that the default letter did not get mailed. So I'm having a little trouble understanding how it's a surprise when it's true. You know, it would have been nicer if the.
I think doesn't bring you a surprise. In fact, meaning surprise that you have this evidence.
But if the witness could have, if the witness were able to, the witness could have also testified about mailing procedures. That was not the case in this situation. So it's the surprise was just as to the green cards, but they're all along the evidence had been that the default letter had gone out.
I can see if there was evidence, there was alternative evidence that the defendant got the letter, and then that would be probably vitiate the idea that there was surprise in fact, but it also would have been evidence that would have sealed the deal in your case. So otherwise, I think the surprise is, hey, I didn't know you had this evidence. You never told me you did.
Well, we are requesting that the court does find an abuse of discretion, because now we've got a 2009 default date. We're going to have to start over again. It's a waste of judicial resources. We would request that the court actually reverse and remand for further proceedings.
Okay. Thank you both very much.
Thank you, Your Honors. I appreciate your time.
Thank you.
Anytime, and